post of work?
Uh, 28/7/2020. 28/7/2020. Page 51 is what's
Over 2 का क्या पेज है आपका? Para number 7, page number 7. Judgment dated 16/8/2019 and award dated 12/8/2019. Anyways, नहीं पता चला इसका record नहीं है. ऊपर लिखिए the counsel for the private respondents has disputed their positions. कब करिएगा बताइए, आपको जो काउंटर फाइल करना है करिए. बिना काउंटर फाइल किए आप कोई भी एक भी शब्द रिकॉर्ड के बाहर मत करिए.
जनवरी में रखूँ.
पोस्ट ऑन 3rd August.
Item, Progress filing item 3, WPL 6414 of 2024.
Annexure 1 and Annexure 3 are under challenge by the Annexure 1 is passed by the controlling authority under the Payment of Gratuity Act, Your Lordship. Your Lordship, may kindly see page number 24 for a minute, Your Lordship. Page 24. Respondent number 4 has made an application before the PG authority for payment of gratuity. Page 24, balance. Second paragraph of page 24. Well, it's only on basis of this finding, the gratuity authority under this act has passed this order of direct payment of 14,16,000. I may be permitted to read this one. After going through the submission of the parties and documents on record, it has been observed that late Biswanath Bhuiyan, working as Gopinathpur OCP under Mugma area of Mrs. ECL and died on one such as and died. The applicant, in support of her genuineness, respondent number 4, has also filed a copy of her Aadhaar card. Hence, it is established that Sri Jabna Devi, wife of late such and such, is the genuine legal heir to the receiver share of the amount of gratuity pending in the name of. Only on the basis of Aadhaar card, Your Lordship, this.
Are you disputing?
Yes, Your Lordship, we are disputing this, Your Lordship. Your Lordship.
Her name is not appearing in the
No, my
records. From where it
She
is?
has impersonated this.
You must have filed your or response.
Malus, may
Where
kindly
is
see
your response?
paragraph 3, Malus, page 23.
No, not paragraph 3. Before the authority. Where is your dispute regarding
Malus,
her
we have
identity?
disputed her identity.
Where
We have
is it? No, it's from the order.
yes, Malus, paragraph 3, Malus, page 23.
Paragraph.
Just next page, right? Page 23, Malus.
Yes.
The opposite party is this petitioner. While their written statement dated 26/8/2022 submitted that Srimati Suknova Bhuini, wife of Delo Bhuiyan, was an employee of Eastern Coalfield Limited. She has opted to retire under the female VRS. One Vishnu Mandal, this is relevant, my lords. One Vishnu Mandal, by impersonating himself as Vishwanath Bhuiyan, obtained employment in Mrs. ECL under female VRS in place of Srimati Suknova Bhuini on 24/12/1985, claiming himself as the son of Delo Bhuiyan and Suknova Bhuini. Doman Bhuiyan, Shiv Shankar Bhuiyan and Somar Bhuiyan, son of Delo Bhuiyan and Suknova Bhuini, made a complaint to the Ministry of Coal, Government of India, New Delhi, which was duly received on 3/1/2017. In the complaint, they had stated that Delo Bhuiyan and Suknova Bhuini were their father and mother, and they were employee of ECL. After the death of Delo Bhuiyan, one Munna Pandit obtained employment by claiming himself as son of Delo Bhuiyan, and Sri Vishnu Mandal, son of late Madan Mandal, village Sri Sachin district of Mumbai, obtained employment in the company under the provision of female VRS in place of Suknova Bhuiyan, impersonating himself as Vishwanath Bhuiyan, son of Suknova Bhuiyan, whereas his actual name is Vishnu Mandal, and he is impersonating himself as Vishwanath Bhuiyan. Now, this respondent number 4 is the wife of Vishwanath Bhuiyan. After receiving the complaint, the management wrote letter to the SP Dhanbad for verification of genuineness, and in response to the management received report of police in which it has been stated that Sri Vishnu Mandal is impersonating himself as Vishwanath Bhuiyan. The above said fact, Vishnu Mandal worked in the company by impersonating himself as Vishwanath Bhuiya. He obtained employment fraudulently by making false representation. It is a well-settled law that salary, pension, and other services such as gratuity and PF are entirely statutory in nature of public service. These rights spring. So we objected to Your Lordship this, and only the finding given by the authorities, Your Lordship, that only on the basis of Aadhaar card submitted by this respondent number 4, her claim is genuine. There has to be some.
She was the wife of the person who was working. Correct?
No, Manoj.
No,
No, Manoj. I may be.
whosoever be the person working, in whatsoever name, was it your case that her name did not appear in the records?
My lord.
Where is that?
My lord, I may be.
You see, when you say that somebody had impersonated, you cannot just have a police report and hold that he was impersonated. There is no criminal case, there is no departmental proceeding. How do you justify it?
Lordship, let me bring all those documents
No,
on record.
not required. Your stand is there here only. You have not initiated any disciplinary proceeding. You have not initiated any
But
criminal
leadership,
case.
fraud vitiates everything.
One fine morning police
Fraud
will-
vitiates everything. Well, it's the very
Fraud is not
very inception,
established.
very inception of the
Fraud is
appointment.
not established by any procedure, either in the departmental proceeding or in the criminal case. How do you say fraud? Fraud is a very strong word. Stronger the word, more onus is on you to get it through. How do you say
Well,
this?
but this finding only on the
There is no
basis.
finding.
Well, that there is a finding
Show
at
me.
page 24. Well, may I appreciate that there is a.
No. Your case is that the person was impersonating himself.
And she is the wife of that person who was.
So where is the finding that he was impersonating himself?
Your Lordship, a complaint was received by the legal heirs of the original employee. Thereafter, we verified.
There was one person working.
Yes,
Did
Your
you
Lordship.
initiate any disciplinary
Your Lordship,
proceedings against
that fact, I will bring it on record. Whether we have initiated any proceeding or not, Your Lordship, let it come in the next week. We'll bring it on record. Well, it's that fact, I will bring it on
Next
record.
week, sir, अगला साल मत कर दीजिए. Unnecessarily, you are creating problems.
Well, I will bring those things on
Counsel for
record.
the parties are present. The learned counsel for the petitioner submits that the order was passed in favor of
Respondent number
the in favor of private respondent who claimed herself to be wife of late Vishwanath Bhuiya, the ex-employee. He submits that the ex-employee had impersonated himself, and therefore his entire appointment and withdrawal of salary, etc., his employment is a nullity in the eyes of law, and it is vitiated by fraud. During the course of argument, the counsel for the petitioner has not been able to satisfy this court as to whether any disciplinary proceedings were initiated against the ex-employee, or whether any criminal case was instituted and he was convicted in the criminal case. He prays for time to file a supplementary affidavit to bring the apostate back on record. At his prayer, post this case on next Tuesday, the supplementary copies.
There is some more time may be given.
Why more time?
Your Lordship, we need this.
No, why do you need to more? You see, firstly, you have not taken such a stand before that point, right?
But the finding of the authority, my lords, that is also only on the basis of Aadhaar card submitted by the respondent number 4. They say the claim is.
It is not your case that she was not his wife who was working over there. It is your case that the person who was working had impersonated himself.
And she is the wife of that.
So
my lords, if that.
impersonation on the face of it is not available on that.
Lord, since 85 to 2019, Lord, he was working.
एकदम नहीं सुनेंगे आपका ये सब बात. CCA नहीं.
It's like easier.
CCA तो यही सब काम है. नहीं सुनेंगे ये सब. जिसको आपने fraud अगर आपने नहीं prove किया है through any process of law, you cannot come and stand and say fraud over here. Fraud is a very strong word. You can't just use it at the drop of hat.
My lords.
Item 4.
Some time. Only 2 weeks time may be given. My lords, we need
No,
to.
I will dismiss it right now. It was never your case that he was convicted or he faced any disciplinary proceeding.
We'll verify
He
those
was
facts.
dismissed.
We'll verify those facts. And we'll bring
Item 4 WPS
Obliged.
6460 of 2024.
Your Ladyship, I pray for a short passing.
Yes, respondent.
For conducting an election in the company,
कौन सा election?
trade union.
यही करना है इसमें. इसमें mandamus क्यों?
short pass on everything.
The prayer is like this. It is with the direction to the respondent number 4 to conduct a election by way of secret ballot.
Who's for this one?
I am here for respondent number 5,
Who's
BSF.
this?
Your ladyship, anyways, the river is not maintainable. There are other High Court judgments which clearly say that for any aspect relating to elections, they are supposed to approach the civil court because it is neither a common law or nor a fundamental right that they are
Where is that
seeking.
judgment? Provide it to me, come at 2:15. उनको भी दीजिए, हमको भी।
Para 12 and para 13, your ladyship.
तो come at 2:15. Somebody else will argue this case.
Item 6, WPL 7038 of 2017.
Worship Senior Worker Board Committee.
Leadership, before my friend start, this is a signed matter, and without any information, the matter has been mentioned and fixed. In this case, Justice Navniti Singh, on the last occasion also, he has argued and he is arguing the case. So I was praying that he has given me instruction. In the month of January, he is out of India also and for some marriage. 24th February, he has said that they will be arguing this case. First, my submission. Second submission is that within 10 days, third election has been conducted and entry in the form B that has also been applied. So I was praying in the meanwhile, I will file the affidavit. If they want to give reply, they can give reply, otherwise it will be gone.
What is the matter?
May cases Mills. In item 6, Mills, I am appearing for the petitioner. Mills, this matter, Mills, was heard on the earlier occasion for a long time. Who refused as he was a party.
Third, but Justice coordinate bench, he
Mills,
was then law of
I have a case. Mills,
When you want the matter to be taken up?
24th February, he has given the date. And meanwhile, I will file that
You wrote
affidavit.
it this afternoon.
Oh, हम तो नहीं sorry.
Yes, when you want the matter to be taken up?
Mills, this month, Mills, I am finding.
He is not available in this month, your ladyship. He has
I don't
asked
know what is the mismatch between both of you.
He has asked me for 24th of February.
आप लोग थोड़ा बात करके आइए. Please talk to the council who is on there.
Yesterday I tried him a lot. सबको मनीष कुमार का दूसरे का नंबर दे दिया. इनका नंबर ही नहीं, डायरेक्टरी में नंबर ही नहीं.
My instructing counsel, Mr. Manoj Mishra, is there.
Manoj Mishra. Who is Manoj Mishra?
हाँ जी, इनका नंबर नहीं मिल पाया कल.
व्हाट्सएप मेरा नंबर इंद्रजीत सिन्हा वार्ड्स के पास में है, मैं काउंसिल के पास में है, उनके जूनियर के पास में भी है, अंकित भी जानता है.
आप किनकी तरफ से?
Petitioner.
की respondent की तरफ से?
Petitioner Telco Workers Union.
Okay. And Mr. Navneet Krishna
is arguing on behalf of respondent number 5 to 8. Yes.
5 to 8.
Yes.
They are seeking adjournment and saying that the matter will be posted on 24th of February. Do you have any objection to that?
Yes, my lord, it's a very long date. It could be posted
This
this
matter is
month.
pending since 2017.
Yes,
So I don't think it's a long date. We have a vacation in the meantime.
yes, I
Have you
understand.
prepared your synopsis of arguments, etc.? Everything done?
Yes, I'll place that, my lords. If my lords may have a shorter date, I just have that.
I think the arguing council is not available in India as informed.
Very well, my lords, I won't quarrel on this. This is thing. So
24th
24th,
February.
24th February.
very well.
With a clear understanding that you will not seek adjournment.
Much of it, I think my lords will mention it.
Yes, of course. WPL number 7038 of 2017. The council for the parties are present. May I have your good name?
Mr. Srivastava.
अनिल कुमार मिश्रा.
Mr.
My name is Manoj Kumar Mishra.
Mr. Anil Kumar Mishra, advocate, has joined online. Are you a senior advocate?
No.
Advocate has joined online. Mr. Manish Kumar, advocate on record.
Manoj Kumar Mishra.
Are you advocate on record?
हाँ.
Mr. Manoj Kumar Mishra, advocate on record on behalf of the petitioner, is present in the court. Ms. Rashmi Kumar, appearing on behalf of respondent number.
I am appearing on behalf of respondent number 8 and senior advocate Justice Namiti Singh will be representing respondent number 5 to 8.
Appearing on behalf of respondent number 8 is present. She, on instructions, has submitted that senior advocate appearing in this case is not available today. The case has been mentioned without seeking her consent, and she prays that in the first week of January, in the month of January and till mid of February, the council will not be available in India. She has requested that the matter be placed for a hearing in the month of on 24th of February. The counsel for the petitioner has opposed the prayer for long adjournment. However, since the arguing counsel on behalf of private respondents is not available for quite some time, this court is inclined to adjourn the matter and place this matter for final hearing on 24th of February 2025 under the heading for final disposal. It is made clear that in case the respective counsels are not available, the petitioner would make alternative arrangements and not seek unnecessary adjournment. The case is pending before this court since 2017. The parties are also directed to prepare short list of dates, synopsis of arguments, and the judgments which they seem to rely upon by much prior to the next day of hearing.
My presence may also my appearance.
Ms. Prerna Dhundwala appears on behalf of respondent
5 to 8.
5 to 7.
5 to 7.
5 to 7.
And I am here for state.
Also for the state Mr.
Sachin Kumar, SC2,
Sachin Kumar,
SC2,
AC.
SC2.
Yes.
In fact, the matter was heard at length. It was fully heard. Before pronouncement, it was
We are
seen
not
that.
concerned with that. It's an assigned matter.
Assigned matter.
That's great. Great.
Item 8, WPC 4867 of 2018.
The dispute is with regard to a bond situated in Chhatara. The dispute is that they are claiming the bond in the lot number 26, 27, 29 is a Jharkhand land. That bond is known as Phansi Talab because it is a moment of the martyrs of freedom struggle of the country, and during the mutiny of 1857, some constables were hanged on the bank of this talab, and therefore this pond is known as Phansi Talab, and several monuments of the martyrs are standing on the brink of this pond. Now they have made an application for opening a jamabandi of this pond. That was rejected by the sub-divisional officer. They made an appeal before the additional collector, that was allowed. Therefore, the state went up to the commissioner, that was upheld. Order of the commissioner, additional commissioner was upheld. Thereafter, it was challenged before the Board of Revenue. They challenged before this honorable that the Board of Revenue is having no jurisdiction. That was quashed, and liberty was given to the state to file appropriate application before the appropriate forum. So, the petition has been filed before this honorable. Lord, may kindly see the order for annexure 1. It will be clear.
What is annexure 5 first? no second revision.
Yes, that has omitted. The order was passed beyond jurisdiction. Therefore, it was quashed by the Honorable Court. The liberty was given to the state to file before appropriate forum.
You are for whom? The private?
I am the it has been filed by the state, Deputy Commissioner Chatra.
State is absent.
No, I am for the state, not.
It has been preferred by the state lordship. It has private respondents.
Annexure 4, just have a look at it. Page 59. At the time, there is a include order, let's have a look at it.
Lord, if I will be permitted to place annexure 1, the order passed by the SGA. Short order notes. May I
If
be?
you are claiming title over the property,
Yes.
go and file your suit. In हर एक case में तो state will come up and say that a suit is to be filed. Go and file your suit. Get your title declared.
If your lordship may say annexure 1, Lord, it will be clear. May I will be permitted to? हजारीबाग अपील बाग संख्या MSN 89 नयन प्रसाद जायसवाल बनाम अभय प्रसाद शंकर प्रसाद दिनांक 17/3/91 के द्वारा आदेश के आलोक में SDM चतरा को डिमांड किए जाने के फलस्वरूप रूप से शुरू किया गया। अपीलकर्ता नरेंद्र प्रसाद जायसवाल थाना चतरा के अंतर्गत मौजूद चौथ खाता संख्या 36 लॉट नंबर 26, 27 and 29 का दावा क्रमशः 1.07.261 और 1.10 एकड़ कुल रकबा 3.77 का लगान निर्धारण हेतु आवेदन दिया गया था। आवेदक द्वारा प्रस्तुत दस्तावेज का अवलोकन किया। अवलोकन ने साक्षी बयान की सच्ची प्रतिलिपि का भी प्रस्तुत किया। खाता संख्या 26 सर्वे खतियान में गैर मजुर्बा दर्ज है। गैर मजुर्बा जमाबंदी उन्मूलन के पश्चात गैर मजुर्बा भूमि बिहार सरकार में निहित हो गई है। फलतः खाता नंबर 26 की भूमि बिहार सरकार में निहित हो गई है। खाता संख्या 36 में विभिन्न प्लॉटों पर स्थित पेड़ एवं लकड़ी का भी बिहार एक्ट 1950 की धारा 3 एवं 4 के अंतर्गत बिहार सरकार में निहित हो गई। इस प्रकार खाता संख्या 36 की जमीन एवं उस पर स्थित पेड़ पर भूतपूर्व जमींदारों कोई हकीयत प्राप्त हुआ और न ही उस प्लॉट पर कोई दखलकार है। इस तरह से उक्त खाता प्लॉट पर जमीन का किसी अलेख अधिकार और न दखल है। नो पोजीशन हुआ। अंचल अधिकारी चतरा के द्वारा प्रतिवेदन क्रमांक खसरा संख्या 26, 27 एवं 29 पर जीवन भगत के वंशज का दशकर्म श्राद्ध इत्यादि कार्य किए जाते हैं। सरकार मनगढ़ंत प्रतिवेदन लगाता है। उस प्लॉट पर राष्ट्रीय स्मारक गाड़ी जयमंगल पांडे एवं नादिर अंसारी का है, जो राष्ट्रीय गौरव का सौहार्द है तथा वर्ष में 3 तिथि को वहां पर समारोह का आयोजन वर्षित किया जाता है और शहर के सभी लोग वहां खुद को समारोह में भाग लेते। टेंट तंबाकू इत्यादि लगाकर भव्य आयोजन होता है। तिथि 15 अगस्त, 26 जनवरी एवं 2 अक्टूबर को होता है। झंडोत्तोलन एवं 2 अक्टूबर को सर्वधर्म प्रार्थना का आयोजन किया जाता है रहा है। वर्ष इस स्थिति में उक्त खाता संख्या 36 के खसरा नंबर 26, 27, 28 किसी का दखल प्रश्न ही नहीं उठता है। That is not enough. That is not enough.
You have got a copy of the report?
There is annexure B, lordship, of the counter affidavit. Report of circle officer.
Let's have a look. Annexure B.
Yes, lordship. Page number 25. starts from page 25.
Yes. And it is
भूमि सुधार उप समारकता चतरा के पत्रांक 1249 दिनांक 22/10/93 के निर्देशों के अनुसार श्री नरेंद्र प्रसाद जायसवाल चतरा के नाम मौजा के अंदर खाता संख्या 36 प्लॉट 26/27 एवं 29 के अंदर 3.78 एकड़ की जमाबंदी जांच उपरांत करने का निर्देश दिया गया है।
ये कहाँ से निर्देश है? It is referring to some earlier order?
Yes, your lordship. Annexure के leadership. It was the order by which it was remanded back to the SDM. The order that my learned friend has just mentioned, that was the remand order, leadership.
Alright. Where is the order? Where is the report of the circle officer? Because at the time of remand also the circle officer. There is a report of the circle officer which has been referred to in Annexure 1 to the regulation. Annexure 1 is dated
16 to 96.
16 to 96. Right? What is the date of report of the circle officer as per Annexure 1? No date mentioned. You are referring to some order of the year 1991.
Leadership with Annexure 2 and 3 is C. We have brought plenty of documentary evidences to show that the disputed land was in our possession and that was mistakenly recorded as Gair Mazerwa Khas land. But the order and Annexure 1.
No steps were taken for correction of the Khatiyan laws. If it was recorded as Gair Mazerwa, it should have been corrected. But it was never corrected. It remained Gair Mazerwa.
Anybody, either of you who is aggrieved, will go and get a declaration from civil.
No, leadership. This is a pure dispute of title.
When it is recorded
Yes,
as Gair Mazerwa.
therefore, if anybody is aggrieved, suppose you are in possession, you don't have anything, right? If they are aggrieved, they want possession, they will go and file title suit. If you are aggrieved, you will go and file title suit. So, but this kind of dispute, which your claim is also based on certain documents, their claim is also based on certain entries made in record of rights. So, this is essentially a matter of suit. We will not decide it here. You go and file this. Either parties, we will not say anything more. Why should we say anything? Anybody can be aggrieved.
Lord, my humble submission, Lord, parties may be directed to maintain the status quo.
No?
Status quo.
कैसा
Till filing of the suit.
वकील की तरह बहस करिए,
Till
वकील की तरह बहस मत
Till filing of the suit.
क्या हो रहा है वहाँ पर?
Rent is being
Heaven is falling.
realized.
Heaven is falling over there.
It is used for public purpose. There is no public submitting.
Protection of right of private parties is the most important public purpose for any state authority. You are mighty. You need a status order from the court to protect yourself. The VPC number 4867 of 2018.
18.
This petition has been filed, heard the learned counsel for the parties, this petition has been filed for the following reasons. The reports of this case reveal that there are serious disputes in connection with right, title, interest and possession with respect to the properties involved in the test. The petitioner is relying upon certain entries made in the record of rights. On the other hand, the private respondent is referring to various documents claiming title considering the nature of dispute involved, this court is of the view that the dispute with regard to right title interest possession cannot be decided in big jurisdiction, and the orders passed by the revenue authority with regard to payment or receipt of rent would ultimately depend upon the title to be decided by a competent court of right title interest possession to be decided by a competent court of civil jurisdiction. In view of their also present circumstances, this court is not inclined to proceed any further in this case, and this petition is disposed of with their
Item 9, WTC 1029 of 2019.
In this case, this petitioner case, he was debarred from giving the evidence. He was the defendant in the title suit lawsuit
title suit relating to
relating to the cancellation of the adoption bill. Suit was pending since 2005 on lordship annexure 3.
adoption.
Adoption deed is under challenge in the title suit lordship.
Whose adoption?
Petitioner's adoption lordship.
Your
The
adoption.
opposite party have filed the title suit.
The
This petitioner is defendant. And lordship,
it is the suit is relating to adoption of which person?
this petitioner
Now,
cancellation Vijay Shah
your adoption is
under challenge.
adoption of Vijay Shah is under challenge.
Yes, lordship.
And who had adopted Vijay Shah?
One Sakuntala Devi, that has lordship
Sushila Devi.
Sushila Devi.
Sushila Devi. She is not the defendant.
No, lordship. Other person claiming he is not the adopted son of the Sushila. That is the
And
case.
Sushila Devi is not a party.
After the death of Sushila Devi, this petitioner has filed, this respondent has filed this cancellation of adoption
After death of Sushila.
after death of the Sushila Devi.
There is a plaint.
Lordship, plaint is the annexure 1 lordship, but this petitioner is aggrieved lordship only that he was debarred from giving his witness, defendant witness. That is annexure 3 lordship. Both parties filed attendance. A time petition has been filed on behalf of the defendant for evidence. Perused the case record. After perusal of the case record, it appears that sufficient time and opportunity has given to the defendant for evidence. Today, the last chance has been given to the defendants for evidence. This case is very old, of the year 2005. I am not inclined to give further chance to the defendants for evidence.
Where is the
In the-
copy of the order sheet?
Lordship, in our counter affidavit, we have brought on record the entire evidence, order sheet, Lordship.
What is the stage of the suit?
Pending for their WS and evidence,
The bill was also not filed.
Lordship.
Yes, Lordship.
They have taken no lordship. They have taken every step to linger the case.
No, Lordship.
Even in this
Just
high.
a moment, did you file WS?
Yes,
Where is your WS?
I have filed WS, Lordship.
Where is your WS? You will give evidence without the WS.
Yes,
Lordship, running page 33 देख लिया मेरे counter affidavit का. That clearly speaks. Order dated 9/5/2023.
Your counter affidavit.
Running page 23, Lordship. नौ 5/23 का मुझे order से. Got the page. May I read, Lordship, that order? वादी की ओर से हाजिरी दी गई है, प्रतिवादी अनुपस्थित है. उनकी ओर से कोई कार्रवाई नहीं की गई है और न ही प्रति उत्तर दाखिल किया गया है. प्रतिवादी के प्रति उत्तर के लिए पर्याप्त समय और अवसर दिया जा चुका है. प्रतिवादी को प्रति उत्तर के लिए एक अन्य अवसर दिया जाना मेरे विचार से न्यायोचित नहीं है.
प्रत्युत्तर क्या चीज है?
रिटर्न स्टेटमेंट
ये 23 में कब का ये केस है? 2019 का केस है. एविडेंस में उसी समय चल रहा था. अब कौन सा रिटर्न स्टेटमेंट की बात कर रहे हैं?
अब जो ऑर्डर शीट कह रहा है.
नहीं, आप हमको ये बताइए 2019 में द मैटर वाज ऑलरेडी प्लेस्ड फॉर एविडेंस. व्हाट रिटन स्टेटमेंट आर दे टॉकिंग
इन लोग के हुजूर इन लोग की तरफ से कोई डब्ल्यूएस वगैरह फाइल नहीं हुआ है.
रिजॉइंडर को बोलते हैं लॉर्डशिप.
रिजॉइंडर क्या चीज का फाइल कीजिएगा? हम लोग के आप ही की तरफ से फाइल होना है. आप बताइए ना.
इसका अपीयरेंस नहीं है. हम इसी ऑर्डर से एग्रीड है इनको विटनेस.
Where is your written statement?
So written statement plant is annexed in
Where
the.
is your written statement?
So written statement is not part of the writ petition, Lordship.
You were asked to file the entire order sheet. Where have you filed it?
Lordship, I have filed the order sheet, Lordship.
Entire order sheet. You were directed to file the entire order sheet. Where is your entire order sheet?
जो supplementary affidavit, Lordship.
बताइए entire order sheet.
Supplementary affidavit. That is Annex 4. Page 7 to 14, Lordship.
ये तो एग्जिबिट पर है, एविडेंस पर है. एंटायर ऑर्डर शीट आपको फाइल करने बोला गया था.
ऑर्डर शीट, लॉर्डशिप, वहाँ से जो ऑर्डर शीट मिला है वो तो फाइल
कहाँ है? सूट कब का फाइल? 2005 से. You were supposed to file entire order sheet. Where is the order?
Lordship, only this petitioner is aggrieved. He was not allowed to produce the defendant witness. Only direction may be given, Lordship.
11 adjournments they were given, Lordship. The learned court below has given 11 opportunity to produce the evidence, and the grounds they have taken that I was busy in cropping of paddy, wheat, and for that reason I could not attend the court for 11 dates, Lordship, continuous. And here also they have taken repeated adjournment.
No, I have not taken.
आपका 6 हफ्ता भी जो हुआ था, 6 हफ्ता भी जो हुआ था अनदर बेंच से.
नहीं, उसके पहले तक.
उसके पहले वो भी आप ही लोग का एडजर्नमेंट है.
Never
6 हफ्ता का एडजर्नमेंट आप ही लिए थे.
आपका Annexure 4 is प्रतिवादी साक्ष्य प्रस्तुत कर. 29/8/2018 was the date on which you were supposed to file your evidence on 10/9/2018. Right? What happened on 10/9/2018? पढ़िए ऑर्डर पढ़िए।
Lordship
10/9/2018
10/9/2018 वादी अनुपस्थित
प्रतिवादी की ओर से विजय शाह की हाजिरी।
यस पिटिशनर इन विजय दाखिल
फोर्टीन 12 को पीओ वाज ऑन सीए। बाय वे ऑफ लास्ट आंसर को कब दिया गया? ऑर्डर ही नहीं पढ़ा था।
यदि इसको नहीं मिलेगा लॉर्डशिप तो फिर विदाउट हियरिंग द रिस्पोंडेंट डिपेंडेंट लॉर्डशिप दिस पिटिशनर order will be passed. That will time will be given lordship. He will produce the witness.
जो हाई कोर्ट में भी देख लिया जाए एडजर्नमेंट कैसे ये
लेकिन हाई कोर्ट के एडजर्नमेंट से हम लोग को मतलब नहीं है। आप पढ़िए कब इनको टाइम दिया?
जो इनको टाइम मिला है
फर्स्ट डेट वर 10/9/18
10/9/18 उसके बाद इनको 6/2/2019 तक के बीच में 11 एडजर्नमेंट दिया गया।
11 एडजर्नमेंट इनकी तरफ से कहाँ?
हुजूर सब इसमें इन्हीं की तरफ से सारा है।
पढ़िए
जी हम लोग काउंटर में लाए हुए हैं।
पहला डेट है 10/9/20
जी 10/9/18 लॉर्डशिप
10/9
उसके बाद
पढ़िए ऑर्डर पढ़िए।
वही हुजूर जो वादी अनुपस्थित है प्रतिवादी की ओर से
आप एब्सेंट थे ना? आप तो वादी हैं।
जी हुजूर
यू वर एब्सेंट ऑन दैट।
आई वाज एब्सेंट।
आगे पढ़िए।
प्रतिवादी की ओर से विजय शाह की हाजिरी दी गई है की ओर से हाजिरी दी गई है he was not present
विजय शाह
की ओर से हाजिरी दी गई है
की हाजिरी दी गई है।
विजय शाह की ओर से हाजिरी दी
और
गई
कहाँ लिखा है?
जी हुजूर विजय शाह की ओर से हाजिरी दी
कहाँ
गई
वोट लिखा है?
जी हुजूर पहला ही लाइन में है। प्रतिवादी की ओर से विजय शाह की हाजिरी दी गई है
हाँ विजय शाह की
जी
और से नहीं। ठीक है, he was not a representation.
और
He was present.
जो परिवादी उसके बाद
पीठासीन पदाधिकारी नहीं।
नहीं
He was absent.
लॉर्डशिप
PO was absent.
पीओ वाज एब्सेंट
PO absent. Just a moment. The defendant filed his attendance.
प्रतिवादी की ओर से
Plaintiff absent. Next बताइए।
नेक्स्ट में हुजूर वादी
18/9
18/9/18 वादी उपस्थित है वादी की तरफ से हाजिरी दी गई है जी हुजूर वादी जयकांत शाह की हाजिरी दी गई है प्रतिवादी की ओर से न्यायालय के समक्ष प्रतिवादी की ओर से न्यायालय में क्या लिखा है
प्रतिवादी की ओर से श्यामकांत की हाजिरी में शपथ पत्र दाखिल किया गया। कोई एफिडेविट दाखिल किया। दाखिल शपथ पत्र पर प्रति परीक्षण अंकित कर मुक्त किया। ठीक है, समझ आ रहा है?
तो हुजूर जब इनका एविडेंस हो ही रहा है तो फिर इसको डिवाइड करने का जरूरत क्या है?
वही ना, यही तो बताना पड़ेगा ना। 18 तारीख को क्या हुआ? वन एविडेंस वाज प्रोड्यूस्ड, क्रॉस एग्जाम।
हुजूर इसमें एक स्टेटस मंगा लिया जाए क्योंकि ये क्लियर नहीं है कि यहाँ पर जो है क्या लिखा हुआ है। एक स्टेटस रिपोर्ट कंफर्म कर लिया जाए।
क्या स्टेटस रिपोर्ट? यहाँ से स्टे है तो क्या ही
स्टेटस उस चीज के लिए कि ये जो डेट पे इसमें क्या क्या स्टेप हुआ नहीं हुआ।
तो ऑर्डर शीट है।
ऑर्डर शीट से हुजूर क्लियर ही नहीं है।
आगे पढ़िए 3/10
वादी जयकांत साहब की हाजिरी दी गई है। प्रतिवादी की ओर से गवाह क्या पढ़िए पंकज जी आपका पढ़िए बताइए। आई क्या कोई
दाखिल शपथ पत्र पर प्रति परीक्षण अंकित किया गया, इसमें भी क्रॉस एग्जामिनेशन।
तब तो उसका ठीक ही है, इनका गवाही आ चुका है, क्रॉस नहीं किया तो मेरा ये अगेंस्ट में जाएगा, मेरे अगेंस्ट में जाएगा।
कुछ और गवाही प्रस्तुत करना होगा ना।
नहीं हुजूर ऐसा कुछ नहीं है, तो लगातार जब करते आ रहे हैं तो अगर
ये इन्होंने टाइम पिटीशन फाइल किया कि हमको गवाही और देना है। अब देखिए 6/2/2019 क्या है।
हुजूर 6/2/19 का ऑर्डर है। टाइम पिटीशन हैज बीन फाइल्ड ऑन बिहाफ ऑफ डिफेंडेंट फॉर एविडेंस। Peruse the case. After perusal of the case record, it appears that sufficient time and opportunity has been given to the defendants for evidence.
Yes.
So
It
sufficient
is
time.
not a case that he was not giving evidence. He was giving evidence. He wanted to give more evidence.
अब हुजूर अगर
2005 से केस पेंडिंग है तो डिफेंडेंट का गलती है, किसका गलती है?
अब हुजूर 11 एडजर्नमेंट तो इन्हीं को टाइम मिला अपॉर्चुनिटी।
आपको कितना विटनेस और प्रोड्यूस करना है? How many witnesses?
3-4 विटनेस है।
ऐसा नहीं है, इस तरह से नहीं है।
Fix.
Exactly बताइए।
और जो भी विटनेस होगा वो टाइम
नहीं
फ्रेम
नहीं
में
ऐसा
कर
इस तरह से 2005 का सूट हम लोग के लाइफ टाइम में खत्म हो जाना चाहिए ना।
इसमें
अब ऑलरेडी जिसका जो अडॉप्ट किया उसका डेथ हो गया, उसका जो डिफेंडेंट है जो प्लेंटिफ है उनका भी डेथ हो गया। अब हम लोग के डेथ होने के पहले डिसाइड हो जाना चाहिए। बताइए कितना विटनेस होगा?
और 3 विटनेस लॉट्स
गेस वर्क
से हम पता कर लेते
पता
हैं।
करके बताइए।
और ये तो बताइए कि रिज्वाइंडर कैची के लिए आप लोगों को फाइल करना है, उसके आगे भी ऑर्डर शिप में वही है।
मुझे उससे कोई मतलब नहीं है, जहाँ से फाइल होना था वही होना। आपके एडवोकेट्स कहाँ गए?
He has gone for instruction.
कुछ तो एविडेंस हुआ है, एविडेंस ऑन एफिडेविट फाइल हो रहा है, प्रति परीक्षण की बात हो रही है। It's not that. You wanted to produce more evidence. इस तरह से नहीं हो सकता ना।
लॉर्डशिप ये ऑर्डर शिप जो है ना पढ़ा ही नहीं जा रहा है।
हमसे तो पढ़ा जा रहा है, जब आपसे सवाल पूछते हैं तो आपको पढ़ा नहीं जाता।
दो 4 ऑर्डर में तो क्लियर ऐसे लेके आया हुआ कर चुके हैं, अधिवक्ता की हाजिरी दी गई, प्रतिवादी की ओर से 7-6 को समय आ गया। लिस्ट ऑफ विटनेसेस
इसमें लॉट से 2 ही विटनेस, खाली डिफेंडेंट का विटनेस है और वही एक विटनेस है।
2 विटनेस बाकी हैं, कुछ विटनेस हो चुके हैं।
ये जो भी विटनेस 3-4 हो चुके हैं, ये भी एग्जैक्ट नहीं बता सकते हैं, वो पूछे तो
क्योंकि कुछ तो विटनेस लग रहा है, वही हो ही चुके
हाँ
हैं।
हो चुके हैं। 2 ही विटनेस, केवल
माय क्लाइंट
केवल 2 विटनेस और देना है आपको,
2 ही विटनेस।
बस यही सी डेट है। चलिए आप क्रॉस एग्जामिन करिए। बताइए कब फाइल करेंगे?
सर
एविडेंस ऑन एफिडेविट फाइल करेंगे, सीधे एविडेंस कराएंगे।
हाँ लॉट से
बताइए।
सिर्फ 1 वीक
बताइए अपने एविडेंस का।
लोग कुछ कॉस्ट वगैरह कर दिया जाता
किसका कॉस्ट
है, लगातार ये समय लिया है।
2005 से कौन समय लेगा?
हम लोग तो हुजूर लगातार एफआईआर कर रहे हैं और इनका
आपके करके क्या ही होगा? गवाही आपका कब से शुरू होगा?
तो हुजूर ऑर्डर
ऐसे कॉस्ट नहीं करें। WPC number 1029 of 2019 for the Learned Council appearing on behalf of the parties. This petition has been filed for the following reason. The petitioner is the defendant in the suit. And the title suit relates to a declaration that the defendant number one is not the adopted son of Mundar Shah or of Mosamad Kushila Devi, and that the adoption deed number 107 for the year 1986 of Godda Sub-Registry Office is illegal, void, and the same be cancelled. By the impugned order in this case reads as follows. Page number 25 in Exhibit. By order dated 5/4/2019, the counsel for the petitioner was directed to file a copy of the order sheet showing therein from which date the case was at the stage of defendant's hearings. Pursuant to the same, the petitioner has filed supplementary affidavit which reveals that the evidence on behalf of the plaintiff was closed by the order dated 29/8/2018 after the plaintiff led evidence, and it was fixed for defendant evidence from 10/9/2018 itself. The Learned Counsel for the petitioner has submitted that the order sheet reveals that on some dates the plaintiff was absent, on a few dates the defendant was absent. आप कभी absent थे?
नॉट इसको स्टेज में है
And on some day the presiding officer himself was not available. He has also submitted that on few dates the defendant led evidence, but he wanted to lead further evidence which was closed by the order dated 6/2/2019 by recording that sufficient time and opportunity was given to the defendants for evidence. And on 6/2/2019, last chance was given to the defendants for evidence, and since the case was very old of 2005, the court was not inclined to give further chance to the defendants for evidence. And the defendants' evidence was closed. The Learned Counsel for the petitioner on instructions has submitted that two more witnesses were to be examined from the side of the petitioner, and including the defendant himself.
Yes,
Including the defendant himself. The Learned Counsel has also submitted that it is not a case where the defendant was not diligent, rather defendant was participating in the proceedings and wanted to give further evidence. The Learned Counsel appearing on he has submitted that the order is set aside and he is ready to adduce evidence in short time as may be raised by us. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the improved order has been rightly passed. The case was very old. After hearing the learned counsel for the parties and upon perusal of the order sheet as placed on record by the petitioners pursuant to order passed by this court, this court finds that the evidence on behalf of the plaintiff was closed only on 29/8/2018 and was fixed for evidence of the defendant only from 10/9/2018. On 10/9/2018, the plaintiff was absent, although the defendant was present. And on subsequent dates, the evidence was led by the defendant. And on one date, that is on 14/12/2018, the presiding officer was not there. This court finds that the defendant was cooperating with the proceedings and was leaving evidence. And on 6/2/2019, his evidence was closed primarily on the ground that the case was withdrawn, without considering the fact that the evidence of the plaintiff was itself closed only on 29/8/2018. Considering the totality of facts and circumstances, this court is of the view that by virtue of the interim order, the defendant has been prejudiced, although the defendant was cooperating with the proceedings. Accordingly, the interim order dated and it has been further submitted by the petitioner that only 2 witnesses are required to be produced further on the side of the defendants. Accordingly, the improved order dated 6/2/2019 calls for interference under Article 227 of the Constitution of India, which is hereby set aside. The petitioner as well as the respondents are directed to cooperate with the proceedings and upon closure of evidence, cooperate with the proceedings and no unnecessary adjournment be given to the parties. And absolutely only 2 witnesses on behalf of the defendants are to be examined. Considering the fact that the suit is of the year 2005, the learned court is directed to decide the suit as expeditiously as possible.
Lordship, only time for producing the evidence may be dictated, Lordship.
ऐसे में नेक्स्ट डेट पता नहीं तो नहीं सकते
जो भी नेक्स्ट 2 कंसेक्यूटिव डेट होगा
अब
2
मान
है
लीजिए कल ही डेट होगा तो कैसे होगा उनको भी तो तैयारी करना होता है ना एविडेंस के लिए नेक्स्ट डेट बताइए कब है
ये विदिन 1 मंथ कर दिया जाए, Lordship.
the petitioner to the evidence of the petitioner be closed within a period of 1 month from the date of publication. दोनों witness आप produce कर दीजिए.
Item 8, WPC 3395 of 2021.
Matter relates to section 71 here. SAR court application filed by the respondent number 5 and 6 has been dismissed.
Where is the application?
Application is not on the record. May I submit one thing? They have also filed counter. We have not filed rejoinder. Any date may be fixed. We will file rejoinder and will bring on the record all the relevant documents.
Where is the state? Produce the records. ऐसा case हम बिना record देखे. The initial application is very important. The mode and manner of disposition and the date of disposition. तो इसमें SAR court का order, appellate court का order and revision court का order. It is arising out of SAR case number.
SAR case number 28 of 2009-10.
Learned counsel for the parties are present. Counsel for the petitioner seeks adjournment while rejoinder to the counter. All the three orders are against you?
No, only one order is against me. The original SAR filed by respondent number 5 and 6 has been dismissed. They preferred appeal. Appeal was dismissed. Thereafter revision was filed. Revision has been done.
The learned counsel for the petitioner submits that the order of SAR court as well as the appellate court. Appellate authority.
Appellate authority.
Was
तीनों का मंगा लिया जाए.
was in
Revision.
favor of the petitioner.
Yes.
But the same has been interfered in the revision jurisdiction.
Well,
Counsel for the respondents is directed to produce the records of SAR case number
it's a 5, 6 and 7.
SAR case number 28 of 2019, SAR appeal number 19R15 of 2011-12, and SAR revision number 49 of 2015. Before this court. Post on बताइए कब करना है?
In the month of January, any date, my lord.
Assigned matter है.
नहीं. My lord का register.
Post on 15th of January
15 को नहीं किया जाए. वो सर करेंगे उनका बेटा का कुछ फंक्शन है. 16 को कर दिया जाए या 14 को या 12 को कर दिया जाए.
13th. Post on 13th of January 2025. The rejoinder be filed by 8th of January. The parties to prepare synopsis, list of dates and the judgments, and also file the judgments which they seek to rely upon much before the next date of hearing. Post for final discussion.
Deeply.
Item 11, WPL 2953 of 2023.
Who's for the petition?
He is out of station, so not today.
Who is out of station?
Mr. Naveen Kumar Singh, Army Council.
What is the matter? Petitioner, what is the matter? What is the nature of order which is under challenge? इतना silence से कैसे ही चलेगा? क्या matter है? नहीं पता.
I'm not.
You are also not aware.
No. The workman has died during the course of reference before the tribunal itself. So the order of termination is set aside, 50% back wages is allowed. They are here before this honorable court saying that 100% back wages.
Not today, Mr. Kumar.
No, madam, day after tomorrow. Anytime.
That would be number 2953 of Learning Council for the parties are present. Council for the petitioner submits that the matter has to be argued by Mr. Naveen Kumar Singh, who is not available today. Council for the respondents has submitted that the reference was answered in favor of the concerned workman who died during the pregnancy of the
Reference
reference, and 50% back wages was granted,
which we have paid and filed supplementary affidavit. That
which
we
the
have.
respondent has paid and supplementary affidavit has also been placed on record. He submits that the petitioner has filed this petition primarily for remaining 50% back wages. Okay. Close this case day after tomorrow for business. To be taken up by the परसों अगर नहीं आए तो आप तैयार नहीं हो
Item 12, WPL 4323 of 2023.
Yes, madam. Arising out of the orders.
Also, we are paying for the permission to see the road court record.
Why do you
We need
आ गया ना देखिए ये आया है ना सवा 2 बजे आ गई राइट ये देखिए आपको देखना आपको नेक्स्ट
लॉसिप कल कर दिया सर
The records from the concerned court have been received. Counsel for the parties jointly seek adjournment for this case.
Item 13, WPL 4351 of 2023.
Leadership in this matter, order dated 3/9/24. The respondent Union of India was directed to file counter by way of last instance. Still, the counter is not filed.
3924.
Passed by Honorable Mr. Justice Sanjay Prashad. Terms of reference is under challenge here, and we have challenged this read petition challenging the terms of reference. नहीं file
3924.
जी
3924 order. 31023.
3/9/20.
ठीक है लास्ट चांस हो गया बस
इसको if he is not filing counter, इसको next week में रख दीजिए. We'll
क्या
find the
चीज के लिए next week
एक
में?
short note कुछ judgments.
कोई शॉर्ट नोट का जरूरत नहीं टर्म्स ऑफ रेफरेंस है ना which you are challenging.
Yes. Leadership इसको next week कर दीजिए. एक short note. नहीं एक में जो कोई नहीं ट्रांसफर पर वो SL अब्बास और पुराना जजमेंट्स जो भी है कि इट इज नॉट एनी सॉर्ट ऑफ अल्टरेशन इन सर्विस इंसिडेंट्स इन सर्विस है उस पर हम चूंकि आज
ये तो रेफरेंस है ना
हाँ टर्म्स ऑफ रेफरेंस चैलेंज
टर्म्स ऑफ रेफरेंस से क्या ही करना है इट विल बी डिसाइडेड व्हाट्स द बिग डील अबाउट इट
डे आफ्टर टुमारो
व्हाई डे आफ्टर टुमारो
काउंटर एक्चुअली आई वाज अंडर द इंप्रेशन कि फिर आके टाइम मांगे
इंप्रेशन बहुत गलत है
कि काउंटर के लिए टाइम
बाय
मांगे
वे ऑफ लास्ट चांस हो चुका है दे आर नॉट इंटरेस्टेड मैटर एंड्स वी आर नॉट इंक्लाइंड इसी को उनका काउंटर करने की जरूरत नहीं है
आप
बिना काउंटर के भी केस डिसाइड हो सकता है अगेंस्ट यू
हां
कोई दे आर नॉट प्रेजुडिस
डिसमिस भी हो सकता है अलाउ भी हो सकता है
टर्म्स ऑफ रेफरेंस होते हैं
इट्स आज
गलत है ना आपको थोड़ा एज्यूम करके मत आया
अभी लास्ट चांस ये लिखा हुआ था ना आई
हो
वाज
गया था
फिर आके सर बोले अब
देयर इज नो पिटीशन सीकिंग मोर चांस फिर क्या चीज का चांस
कभी आके भी बोल देते हैं कि नहीं देना जरूरी है टर्म्स ऑफ रेफरेंस से मेरा डिपार्टमेंट का ऑर्डर है हम डिफेंड करेंगे
ऐसे
उसको
बोलने से ऑर्डर नहीं करते
जी
लास्ट चांस हो चुका है वो जुडिशियल ऑर्डर का कोई मायने मतलब नहीं है इट इज अ वेस्ट ऑफ पेपर
लास्ट चांस मींस लास्ट चांस
सी द मैटर इज ओवर यू आर्ग्यू द केस
सर भी नहीं है बोल
Petition in this matter, Mr. Sachin Kumar will argue the matter petition. Sachin Kumar.
Mr. Sachin Kumar will argue for whom?
The
Respondent number 6
respondent union, workers union.
श्रमिक यूनियन
वो हम तो inclined ही नहीं है डिलीट देने के लिए, तो आपको कोई डिवाइस नहीं होना चाहिए. I'm not inclined family. कोई काउंटर का जरूरत नहीं, आप हमको पता है ये स्टे है क्या है. There is a dispute, it has been referred. कुछ तो बताइए ना. What is the ground? Just let us know.
हम लोग इसमें बस इसी पॉइंट पर अपना आर्गुमेंट को कन्फाइन करेंगे कि इंडस्ट्रियल डिस्प्यूट जो सेक्शन 2K में है उसके एम्बिट में ये नहीं आ रहा है. हम लोग अपना आर्गुमेंट ट्रांसफर ऑर्डर हम लोग उसी के पर्व्यू में अपने आर्गुमेंट को कन्फाइन करेंगे.
लेबर कोड नहीं करना.
बस
You see whether the transfer order was in terms of the work order, of the standing order, whether it was in terms of the contract of employment.
जी.
Right? There can be a contract of employment which says that there will be no transfer.
सिर्फ इंडस्ट्रियल डिस्प्यूट जो 2K में डिफाइन हुआ है उसमें है कि अगर कोई एम्प्लॉयर और एम्प्लॉय के बीच में डिस्प्यूट हो तो इसमें कोई ट्रांसफर को लेकर डिस्प्यूट नहीं था और विदाउट लास्टली सीधे वहाँ फाइल कर दिया गया और वहाँ से टर्म्स ऑफ रेफरेंस हो गया. तो इसको बस मेरा ये कहना 2 दिन के बाद रख दीजिए और इसमें ऑब्जर्वेबल ऑर्डर में कर दिया कि नहीं फाइल किया तो उस दिन फाइनली इसको सुन लिया जाएगा. आके उस दिन भी नहीं आएगा. नहीं कोई स्टे
तो
नहीं
फिर तो वहाँ पे चल रहा होगा लेबर कोड.
ऑफिसर ही नहीं CGIT है ना, इट्स वैकेंट सिंस लॉ. ये प्रॉब्लम ये तो यदि इन्फ्लक्चुअस हो जाता केस.
अब बहुत बड़ा प्रोपोजिशन ऑफ लॉ
चाहते हैं कि इस पर मैं सिर्फ कुछ नया इस पर डिसाइड हो जाएगा क्योंकि ऐसा
डिसाइड होगा. ट्रांसफर कैन आल्सो बी डिसाइडेड.
ठीक है. लीडरशिप मेरा काम है केस आर्गू करना. लीडरशिप इज इंक्लाइंड नॉट इंक्लाइंड वो तो जो इन अकॉर्डेंस विद लॉ होगा आप ऑर्डर कर दीजिएगा. आई कांट फोर्स द ऑनरेबल कोर्ट. मेरा काम है केस को अपना डिपेंड करना. प्रोवाइडेड सर जिस दिन रहे उस दिन रख दिया जाए.
काउंटर भी फाइल हो सकता है.
हाँ, इन लोगों की तरफ से काउंटर फाइल.
बताइए.
Leadership in January because the marriage is in senior son of leadership. That's why he won't. I'm not sure leadership very
पहले नहीं आ रहे हैं ना.
पूछना पड़ेगा leadership.
पूछ के बताइए.
Yes leadership.
ऐसा नहीं है कि एक कोर्ट में आ रहे हैं दूसरा कोर्ट में नहीं आ रहे. ऐसा तो नहीं होता. पूछ के बताइए कौन सी. You go and ask.
Yes leadership.
उसको डेट बताइए कंसेंट डेट.
Sorry to Mother, the previous matter, can it be at 2:15 tomorrow, Mother? 2 matters are specially fixed. Outside counsel is coming.
Other side one.
He's here. I have to ask him.
To be taken up at 2:15.
Okay.
Final discussion.
Yes, my lord.
Final discussion. The previous matter कौन सा है?
Item 12.
Item 12. आपकी petition.
WPL 4323 of 2020.
Item 14, WPL 4708 of 2023.
We have challenged order dated 8/12/2022, that is at annexure 5, page 33-35, wherein the amendment has been allowed, filed by the private respondent, the respondent here, petitioner there, and the case was filed under WC Act, and the cause of action that has been amended as per the application under the WC Act. The death occurred of the husband of the petitioner, of the respondent, on 20/10/2015 at 7:50 p.m. while returning from general staff duty from CCL KDN project dashed by the truck. This is the amendment. Annexure 3 may kindly be seen.
This is Workmen's Compensation
Yes.
Act.
Yes.
Right?
Yes.
So workmen must have expired.
Yes, ladies. Annexure 3 may kindly be seen. That is the amendment application. That is at page number 26-27. Initially, the application, the time, and while returning from the duty, this was the application made before the court below. And this is the amendment application, para 1, that by this application, claimant prays for following amendment in claim application. In para 2 of the original claim petition, it is mentioned that on 20/10/2015 at about 7:50 p.m., Kuldev Ganju was returning his residence after completion of his duty when he reached. This sentence is required to be replaced by on 20/10/2015 at about 7:50 am. Kuldev Ganju was going to join his general shift duty at CCL KDH project from his residence in the meantime at. Next, in para 5, the original claim petition, it is mentioned that the aforesaid workman died due to accident arising out of in course of his employment under the opposite party when he was returning home after the completion of his duty. This was the main application. In this para, when he was returning home after completion of his shift duties. What is the
time of
morning? 8 o'clock. Ladyship, after closing of my evidence, when his evidence was closed, he came and gave his deposition that he never joined the duty on 20th. Then this amendment application has been filed. Nothing. Why it has been wrongly mentioned? AM PM is understandable, ladyship. While returning from the duty, while coming back home, he said that he was dashed by the offending vehicle and he succumbed to the injuries. And this application itself, no inadvertence, nothing has been mentioned. Why
is it numbered as WPL? This is arising out of
WC? WC matters.
WC matters. The first appeal lies against
MA lies in the final.
MA lies against the final.
Final. This is the amendment has been allowed.
And therefore
there.
Where have you stated that your evidence was closed?
Yes, Village. My humble rejoinder may kindly be seen at Annexure 4. No, nobody is appealing. The notices were issued. It has validly been served.
Rejoinder, it was through publication.
It was yes, 5 to SA. Yes,
paper publication as well.
Paper publication was on direction was on 19/7/24. Thereafter, essay was filed showing the paper publication. 31/8/24
What was the stage of the case? From where did I get that?
I'll bring the stage of case. So that stay was granted to us.
Stay must have been granted.
Yes.
But at what stage this amendment was played for? From where do I get that?
Yes, after that is there in the order itself. सेकेंड पेज में देखा जाए ऑर्डर का रनिंग पेज नंबर 34 my pleadings per contra the learned counsel for the opposite party has argued that proposed amendment is misconceived, magnified, concocted and based on hypothetical premises. The learned counsel has further argued that the amendment application has been filed after closing the evidence of the claimant and hence it is delayed. So it is not no, my evidence was also closed. My rejoinder may kindly be seen. One Shekhar and prove the evidence. Para 6. That the statements of the claimants in her amendment petition para 1, subpara 1 and 2 are highly objectionable after the closing of the evidence of the claimant and also after reducing evidence on behalf of the respondent opposite party CCL wherein and whereby OPW1 Navneet Shekhar manager personal CCL disclosed the facts and falsified the claim of the claimant. When I led my evidence, I brought on record. The attendance register was brought on record, proved the other documents. And when I said that the time of the occurrence was such and such, and it is not just a mistake of PM and AM ladyship. It is not a minor mistake of PM and AM. There is a specific statement while returning to his residence. That has been amended while going for the office. The entire cause of action changes, ladies and gentlemen.
I am still not able to find out that your evidence was also registered.
I bring my evidence on record.
Because
At
only
that
the
best,
claimant's evidence was disclosed.
No, my evidence was led. I have stated that that has not been denied by the respondent.
You led evidence that
Yes.
the accident happened in the morning.
In the morning, and by that time he means the claim application was that it happened in the evening while returning to his residence from his place of duty. My evidence, I led the evidence that it happened in the morning, and it was not the time while he was returning from the duty any accident. He never joined that duty on that particular day. I brought
You did
attendance.
not join the duty on that.
Huh, no. I brought the attendance register on record. I brought, when that was brought, I led my evidence, not the amendment that I have shown, ladies. And why such
Was
statement?
your duty in the morning?
Morning, that first shift I have written.
First shift he was on duty.
Yes, first shift.
So accident actually happened while he was returning from first shift.
No, it happened in the morning.
While he was returning from first shift duty.
First shift, morning, it starts. So he was not returning at that time. The entire claim application is based on.
There is a claim and there is a written statement.
Yes. Annexure 1 is the claim application, which has been correction has been incorporated. Annexure 1. Show cause filed by the petitioner. This is my show cause. Para 8, may I read from the beginning of para 8? That the statement of the claimant in paragraph 2 of the petition is false and presented in fabricated and twisted manner, and rest matter are the matter of records based on evidence which the claimant must prove at the time of hearing. If necessary, the CCL opposite party would produce documents to controvert these statements. The matter of the fact that as per the official record that late Fuldev Ganju was brought to emergency at the Central Hospital Dakra at 8 am on such 20/10/2015, that emergency number 3274 dated 2010-2015 and admitted with admission number 707 dated 2010-2015 at 8 am, and thereafter he was referred to Gandhinagar Hospital for further treatment. The statement of the claimants in paragraph 3 and 4 of the claim petition are matter of record. That the statement of the claimant in paragraph 5 of the petition is false and fabricated and hence denied by the opposite by the respondent OP. The respondent OP specifically submits that the accident has not occurred due to accident arising out of and in the course of employment. It is further submitted that Fuldev Ganju was employed in the general shift, and as per the last attendance report signed by the mine timekeeper KDH and vetted by assistant manager KDH, the counter signed by the personal in charge KDH, the Fuldev Ganju last date of attendance is 19/10/2015 and he was on sick from 20/10/2015 to 28/10/2015. Therefore, it is clear that he was not on duty on 2010-2015 and he was admitted in the morning of 2010-2015 in Central Hospital, Dhaka, and the claim of the petitioner that late Fuldev Ganju met with an accident while returning from his duty, that is after completion of a shift on 2010-2015 at 7:50 p.m. and also that he has died due to accident arising out of and in the course of employment is false and baseless.
What does that mean? He was on sick from 2010-2015 to 2018. He was on sick means? What does it mean?
Sick 2010-2015 to 2018. This is a statement edition but no document in the case.
Could be that he was on duty on 19-10-2015 in the late shift. Before 12 o'clock.
At night. No, but then the amendment application says that he was, the accident occurred on 20th
while he was returning.
while he was going. Entire thing has been changed.
While he was going?
Going for the duty, yes.
So, the amendment petition is where?
Annexure 3, ladies.
He was going to join.
Yes. So AM PM is still reasonable, that we can understand. There can be a mistake on the part of the applicant there, but entire fact has been changed. And why the earlier facts were mentioned, that has also not been mentioned in the amendment application. Simply stated, these are the amendments. No reasoning, nothing has been given. It is as good as an order, ladyship. That is, it should be read as this should be read as this. Why it should be read as this? There is no, it is not an application.
In the Workmen's Compensation Act, the strict rule of evidence is not
No.
So it will ultimately depend upon the materials which are brought on record. Parties may not be bound by the pleadings also.
Ladyship, but after, when we adduced our evidence, we adduced our documents, those were marked as an exhibit. We proved those documents, and thereafter the entire facts have been changed. It was never their case. When we said no, that he never joined duty on 20th, then the fact has been changed to that extent that no, accident happened in the morning, and while returning from the duty has completely been changed to while going to the duty. And
WPL number 10 of 20. What is the present status?
it is stay has been granted thereafter. We move before this honorable court. Stay was granted on 19/7/24.
The applicant has been appearing before the court, even in the year 2024.
Yes, but he is not appearing. And the notices were validly being served upon the respondent. Thereafter, paper publication was also directed. Yes. It is that order dated 19/7/24. May kindly be seen.
WPL number 4708.
Leadership of the leadership.
The learned counsel for the petitioner submits that notice issued to the sole respondent was validly served. Upon the sole respondent, and this has been recorded in order dated 19/7/2024 also. But this court was of the view that the notice may be served upon the sole respondent through paper publication also. Consequently, an order for paper publication, the order for substituted service of notice was passed on 19/7/2024, and pursuant thereto, the notice has been served through paper publication and supplementary affidavit with regard to the same. The learned counsel submits that the sole respondent is deliberately not appearing before this court. She has argued the case on merits. This petition has been filed with the prayer to set aside the order dated 18/12/2022 in Matter Election 5, passed by the Commissioner for Workmen Compensation Presiding Officer and Labor Party in WC case number 1 of 2020, whereby the learned court has been pleased to allow the amendment filed by the respondent. She submits that the husband of the applicant before the learned court was under the employment of the petitioner, and upon his death on 20/10/2015, a petition was filed seeking workman's compensation. She has submitted that at the advanced stage of the case, and after completion of the evidence on behalf of the claimant, a petition seeking amendment was filed. The amendment petition has been brought on record as per meeting in the 3. Submits that upon perusal of the amendment petition, the entire case is sought to be closed.
And I led my evidence in the court thereafter this amendment
She
application.
submits that the petition for amendment was filed after the petitioner has led evidence before the learned court by defending the loss. she has submitted that the specific case of the claimant was that the accident had occurred on 20/10/2015 at about 7:50 p.m. when the ex-employee was returning, when the concerned employee was returning to his residence after completion of his shift. And the amendment sought for was that the accident had taken place on 20/10/2015 at about 7:50 p.m. when the concerned employee was going to join his general shift duty. She submits that as per the written statement filed by the petitioner before the court, the concerned employee was in general shift and as per last attendance report, his last date of attendance was 19/10/2015 and he was on sick from 20/10/2015 to 28/10/2015 and therefore he was not on duty on 20/10/2015 and he was admitted in the morning on 20/10/2015 in the central hospital. She submits that the case of the claimant that he met with the accident while returning from duty from his shift on 20/10/2015 at 7:50 p.m. and died due to accident arising out of in course of employment was duly disputed on behalf of the petitioner in their written statement. And after the petitioner laid evidence, the amendment was filed to make out a new case altogether without any statement as to how and under what circumstances the initial statement was made. With she has submitted that the learned court has allowed the amendment by observing that the strict rule of evidence is not applicable and Workmen's Compensation Act is a regulatory She has also submitted that those strict rule of evidence and pleadings are not applicable in connection with workmen's compensation case. But the impute order allowing the amendment has enabled the claimant to make out a new case altogether. She has submitted that ultimately the case has to be decided on the basis of materials. After hearing the learning counsel for the petition and upon going through the materials based on record, it is evident that the claimant had made a claim that on 2010-2015 at about 7:50 p.m. the concerned employee was returning to his residence after completion of his shift, and while coming back he met with the accident. And the amendment sought for was that on 2010-2015 at about 7:50 a.m. the concerned employee was going to join his general shift duty at CCL in KDH project from his residence, and while going to join duty he met with the accident. The written statement of the petitioner also reveals that the concerned employee was admitted to hospital, was admitted to emergency of Central Hospital, Dhaka at 8 a.m. on 2010-2015. Thus, the time and date of accident on 2010-2015 at and around 7:50-8 a.m. is not in dispute even in the.
We said, they said it is PM. We said it is
AM. You said AM.
Yes.
But at least this time and date is not in dispute from the written statement also.
Yes, they admitted to that it is AM.
Yeah.
Yes, yes.
This court is of the view that the strict rule of evidence and duties are not applicable in workman compensation cases. And it is a beneficial legislation. And under all circumstances, the entitlement of the concerned workman with regard to compensation has to be identified. Considering the future circumstances, this court is not inclined to interfere with the interim order dated 8/12/2022. And under Article 227 of the Constitution of India, and accordingly this petition is means
Item 15, LPL 969 of 2024.
have looked at a short list of it well. And your lordship, the judgment that it's a case that has been whereby your lordship, the learned court below has passed an award against the petitioner's lordship, where the employer of the respondent. So before taking your lordship through the award, your lordship, may I just refer to the application that was filed before the presiding officer Labour Court at Dhanbad. That was the original claim application that was filed before the Labour Court at Dhanbad. Lordship, it is a case which very near, lordship, the employee was working in a newspaper and they are governed by Working Journalists and Other Newspaper Employees Conditions Miscellaneous Provision Act 1955. It's a special law, lordship, which provides for a remedy in case of a working journalist and also in case of a non-working journalist.
Okay.
I checked, I have not seen it. I'll admit to that. Lordship, the case that we are trying to make out, there are 3 rounds. Lordship, the application is at Annexure 2, page 33. Lordship, before referring to that, may I just frame your lordship on what points your lordship I am going to argue. There are 3 points, your lordship, on which I am going to argue. Firstly, it is an admitted case. It is an admitted case as per the claim, as per the award also, that the employee was a non-working journalist. My stand is that in terms of, your lordship, the section 3 of the Working Journalist Act 1955, only a working journalist can take the remedy or recourse under the ID Act, under section 3. That is the first ground that I would be trying to raise before your lordship. Section 3 of the Working Journalist Act 1955. It completely says, your lordship, working journalists and other newspapers, employees, condition of service and miscellaneous provision Act 1955. Section 3.
How is it related to ID?
Lordship, section 3 itself provides that in case a working journalist has any kind of issues with the management, then he can invoke the provision of IDA. But it only provides for a working journalist, not for a non-working journalist. For a non-working, sorry. Yes, Lordship, that has also been defined under the Act itself. The 2 segments.
So you want to say that it is an admitted fact that he was a non-working.
Exactly.
So therefore the jurisdiction was wrongly exercised.
Exactly.
Was that an issue framed?
Yes, sir. That was the issue frame, and that was also answered by the tribunal in a very obnoxious manner, if I may say so. Because firstly, the tribunal also held that he is a non-working journalist, whereas this.
So where do you say that there was an admission?
Yes, sir. If your lordship will come to Annexure 2, page 33 itself, that is their claim statement. Lordship, may I just frame 2 more issues and thereupon go on to this? Lordship, secondly, for a dispute, there has to be a reference to the management made by the workman raising a dispute. In case the management does not agree to that, only then there would be a cause of action to approach any court for a dispute settlement. There has to be a dispute raised to the management. Yes, sir. Condition precedence was not satisfied. And thirdly and lastly,
did they went to any conciliation?
yes, sir. They did went into conciliation. They did go into.
You say that even before the conciliation, some demand was required.
Yes, exactly.
So you never challenged the reference?
No, there was no reference. It was a direct case before the Industrial Dispute Act, before the Industrial Dispute Court, Labour Court.
Under section 2?
Under section 3, read with section 2. 2A.
So for 2A, there is a procedure that
Yes.
he has to make a demand.
Yes, sir.
Before the conciliation officer.
Yes, sir.
And if the dispute is not referred, you can directly invoke.
Yes,
exactly.
Yes, sir. That was what was done.
That was done.
That was done. Admittedly done. Lordship, I would be trying to raise that issue because I have come up with some judgments which is on this particular point, that merely by raising a dispute before the conciliator or before the conciliation council and not raising a dispute before the management itself would not amount to be a dispute. Because firstly, a dispute is to be raised before the management. In case he is aggrieved by that particular decision, then it is required to be ventured with the.
Let us see to me.
Yes. May I place it? Dismissal, etc., of an individual workman to be deemed to be an industrial dispute. where any employee discharges, dismisses, retrenches, or otherwise terminates the service of individual workmen, any dispute or differences between the workman and his employer connected with or arising out of the discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute. So first and foremost is that there has to be a dismissal, termination, or whatever nomenclature we call it from. And it is an admitted case before the tribunal that there was no dismissal, there was no termination. I'll show. I'm just framing the law, Your Lordship, thereupon the issues, and thereupon I'll refer to the statement to suffice this particular argument.
No order of termination.
There is no order of termination. Admittedly, there is no order of termination. In the claim only, I'll read from the claim only these two propositions. That he was a non-working journalist, and second, there is no termination.
If there is no order of termination,
Then 2A is itself.
itself
Absolutely.
उससे ज़्यादा बोलने की क्या?
Absolutely.
बताइए आप।
Absolutely.
बताइए कहाँ है?
Yes.
that we never
Yes.
had any
Yes.
grievance regarding
Yes.
termination.
Yes.
Otherwise, the case cannot come directly to the
Exactly. But firstly, may I on the first point? जी. जी जी.
कितना point कर? काफी नहीं है?
लॉर्डशिप बस एक लाइन जो लिखे हैं अपने डिसमिसल के बारे में वो हम दिखा रहे हैं पेज 36 Page 36 and 37 I would be referring to, Your Lordship, because there are two paragraphs which are somewhat different, but that is what it has been said. That after passing of the above 1.5 year, has Your Lordship, after passing of 1.5 year, when the petitioner was moving, he sent an application to the labour superintendent on such and such. Thereafter, the labour superintendent sent a letter to the OP on such and such, while letter number such and such. But the OP neither appeared before the officer of labour superintendent nor gave a reply to settle the dispute. And the said labour superintendent directed the OP to file a case before the competent court of law. His letter number such and such. Thereafter, the petitioner went to join the office of OP on 16/6/2021 for joining his services, but the OP was forcibly removed from his services without any dismissal, and also deny his identity as a workman. And secondly, Your Lordship, if Your Lordship would just turn a page.
This is a verbal discontinuity.
Yes, sir. That is what they are trying to convince. Now, if Your Lordship will turn a page. Paragraph 12. Paragraph 12. That the workman is a staff of OP and till now he has not been dismissed from services.
Because they have not issued any letter.
There is no order of dismissal, but you have been discontinued.
Yes, sir. That is what they are trying to. That is what they are trying to canvass. Now, this is the second issue. That firstly, there has to be a reference made to the management, and after a reference, only a dispute can be.
This 2A so far does not refer to any reference.
No, it does not. It does not. It does not. But I'll refer to the judgment, Sir. I'll refer to the judgment on after considering these very aspects itself.
2A is talking about raising a dispute before the conciliation.
Yes, sir.
And if the conciliation officer
Does not entail any kind of consequence thereupon, then it can go to the labor court.
just a moment, just tell us one. Here, he raised a dispute before the conciliation. Thereafter, he makes a statement that he went to work, but he was discontinued.
He was not allowed to resume his duty.
This is आपका statement ही पढ़ेंगे।
paragraph.
उसके beyond तो कुछ नहीं पढ़ेंगे।
No, page 30.
Thereafter, the petitioner went to the office of the OP for joining his service, but OP forcibly removed from his service
Without
any dismissal. So, what is the date of removal? Date of removal is 16/6/2021.
Yeah.
And conciliation is prior.
Is there any conciliation post 16/6/2021?
Yeah.
So, let us where is it?
Just one more page, if I may refer to page 34, date of conciliation has been mentioned. Page 34, in their own petition. The first line. As you receive first line. 15/6/20.
Yes. Conciliation is 15/6/21. The conciliation तो आप dismissal में फिर पहले ही गए थे ना conciliation.
Conciliation के बाद, after the conciliation.
Conciliation के बाद आप गए join करने.
Yes. But they have
आपको
not.
join नहीं करने दिया and you assume that you have been dismissed without any order of.
Prior to that month, they have not allowed to perform my duty.
कहाँ है?
As will appear from the. Kindly see it.
Prior to that, they were not allowing you to perform duty, but you were dismissed. बोल के कहाँ? Date of removal of 16/6/21 लिखिए अपने petition में. Annexure 2. Date of removal 16/6/21.
First page.
First page.
Para 4.
Para 4 बाद में पहले first page में आएगी. Annexure 2 first page.
Page 35.
Page 33 तो पढ़ेंगे ना, 33 के बाद ही 35 आएगा.
हाँ, 33.
पढ़ी. Date of removal.
Date of 16/6/2021.
इसके बाद कौन सा कंसिडरेशन?
इसके बाद तो नहीं. Prior to
कैसे इन्वोक की? टूए का कंडीशन प्रेसिडेंट है कि आपको डिसमिसल करने के बाद you have to go to the conciliation officer, and if the conciliation officer does not act accordingly, then within some time, then you can directly invoke. This is a deemed industrial dispute. Dismissal of a workman is a deemed industrial dispute.
But the case is that not that when they opposite party number to met an accident, thereafter he went to
इस
join.
केस से कोई मतलब नहीं है ना. jurisdiction का बात है तो jurisdiction पहले satisfy करिए, उसके बाद आपका केस तो बट डिटेल लेकिन आप में आते हैं इस सवाल का जवाब.
नहीं, हम अभी दिखाते
हाँ,
हैं.
बताइए.
LC section 2A of the Industrial Dispute Act. Dismissal it is the individual workman to be deemed to be an industrial dispute. Whether any employee discharged, dismissed, retrenched or otherwise terminated his service on individual workman, any dispute or differences between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment or termination shall be deemed to be an industrial dispute with a standing that no other workman nor any union of the workmen is party to that dispute.
Two.
But not understanding anything contained in section 10, any such workman as they specified in subsection 1 may make an application direct to the labor court or the tribunal for adjudication to the dispute referred to thereafter expiry of 45 days of the date of is made an application to the conciliation officer of the appropriate
thereafter after the expiry of 45.
Make an application direct to the labor court or the tribunal for adjudication of the dispute referred therein. After the expiry of 45 days from the date of he has made the application to the conciliation officer of the appropriate government for conciliation of the dispute, and in respect of such application the labor court or the tribunal shall have power and jurisdiction to adjudicate upon the dispute as it is where the dispute referred to it by the appropriate government in accordance with the provision of this act, and all the provisions of the act shall apply in relation to such adjudication as they apply in relation to an industrial dispute referred to the appropriate government.
तो सबसे पहले this provision is required to be satisfied before you invoke it.
Yes.
कहाँ?
So that means
It is not a formality. It is a mandate of law.
yes.
आपका date of dismissal है 16/6/2021 as per your condition.
Yes.
And thereafter you have not approached the conciliation officer for anything. Straight away you have raised the dispute.
Then the matter may be remanded.
Remand नहीं होगा ना. Without jurisdiction ऐसे decide होगा. And liberty will be reserved with you to take appropriate steps.
Okay.
Yeah. This much should suffice.
Yes, sir. There are other issues also, but
And
it
let
will
us
be
see
raised.
how the learned court has
Yes, sir.
dealt with this.
But this issue has not been framed.
Worship, it was an ex parte award. It was an ex parte. That was my third ground. That only once there was a notice that was issued to the petitioner here in your lordship, which was never validly served, your lordship. I have annexed the order sheets also, your lordship, from page number 41 onwards to my memo, your lordship. page 41 onwards, if your leadership will have a look at. So it was an ex parte award.
Page 41.
Page 41. The last but one order here, so 1/9/2022. Due to holiday on such and such, sorry, page 41. Last but one order. Due to holiday on such and such, record is put up today. Learned counsel for the appellant files postal receipt and tracks report, which does not show delivery of notice. Ajay, let's correct.
Yes.
Thereupon, learned counsel on the next date I'm reading. Learned counsel for the applicant is present. Applicant is directed to submit the updated SR by the next date. Similarly, goes on the next two dates also. It also says that there is no service report that is there. Then on
And
20.
files postal report.
Yes, I'm just
as well as
reading.
copy of RTI application.
Exactly. RTI application. I'll just read that. Learned counsel for the applicant is present and files a postal report as well as copy of RTI, which applicant has sought information or service report notice. Next date. Learned counsel for the applicant is present. It appears that there is no progress.
Notice issued against, this is with regard to SR of notice issued, service report of notice issued.
Yes, sir. So RTI was filed into that regard
For service report.
for service report, but that was not found. Thereupon, learned counsel for the applicant is present. It appears that there is no progress in the process issued to the OP, and hence the applicant is directed to take step for publication of the same in the newspaper.
Thereafter, the notice was published in the newspaper.
I'm just reading it, sir. I'm reading it. I'm not leaving it. Then on the next date, 5/9/2022, the application is filed for issuance of notice. And if your ladyship will have a look at the third paragraph, applicant is directed to take steps for paper publication in local Hindi daily newspaper published in Dhanbad. Example, Awaz Prakashan. That is the petitioner. Firstly, somehow, but it was not published in Awaz Prakashan. It was not published in Awaz Prakashan. It was published in some other daily. Dainik Bhaskar or Prabhat Khabar or Hindustan put upon such and such for appearance, and thereupon the paper publication was filed and the proceeding was ex parte.
So no notice was validly served. As the substituted service was published in the daily.
Substituted service कब होता है? What is the condition precedent for a substituted service?
In this case,
No, not in this case. What is the principle of substituted service?
when the notice was not served.
Not served. When the person is stressless, you're not able to find out. You get the notice published at the last known address.
Because when the
If there was no service report,
petitioner is the
if there was no service report, fresh notice should have gone. Isn't it?
since beginning, Lord, he has not appearing in the conciliation proceeding. He has not appeared in the conciliation proceeding. He has not appeared.
We are not bothered about conciliation, right?
Thereafter, Lord, the notice was issued.
Notice was issued, the service report was not received.
Yes.
The petitioner was not caseless.
Petitioner
Petitioner is an organization having
Yes.
a permanent office.
Yes.
Then you take steps through paper publication
Yes.
and then proceed ex parte.
The paper publication was published in the Dainik Jharkhand. Petitioner is also the paper publication also.
Of Dainik Jharkhand.
No, petitioner is the Awaz. Awaz is the paper publication. Lord.
आवाज में तो आपने पब्लिश ही नहीं किया.
ना इसमें दिया हुआ कि 3 पेपर की आवाज प्रकाशन, दैनिक भास्कर और प्रभात खबर.
इस तरह से न्यूज़पेपर आप जरा देखिए सीपीसी में सब्स्टिट्यूटेड सर्विस ऑफ नोटिस का वर्क कैसे होता है. You know there is a petition required for filing a substituted. There is some statements are required to be made in substituted service of notice.
Yes. As would appear.
That the person is not traceable or he is avoiding notice. ऐसा तो कोई स्टेटमेंट नहीं है, कुछ नहीं है. कैसे इस तरह से इस इशू को डिसाइड करें, यहाँ से लिख करें. एक्स पार्ट है तो वहीं से करें. वहीं से करें. It will be one of the issues to be framed.
Yes.
ठीक है?
All the issues to be left open to the Labour Court to decide, including the issue of
Did
material.
the Labour Court frame issues?
Only page number 81.
Page number 81. And then
Paragraph 3. Just above point.
paragraph 3. No, it is not the case that he did not appear. It's a case that the service report was not filed. So read paragraph 3.
Notice was issued on 3/8/2022 appearance for the OP. In spite of several opportunities given to the OP did not appear ultimately on.
Did not appear का बात नहीं है ना, सर्विस रिपोर्ट है ही नहीं तो कहाँ से appear?
They are kindly. Ultimately on 5/11/2022, the order was passed for publication of notice in the local newspaper against the OP. Notice was published in Dainik Jagran on 7/11/2022.
You see, OP did not appear,
Yes.
and therefore paper published. This is an error of record. There is no service report. सर्विस रिपोर्ट है कहीं नहीं है ना भाई, हमको ऑर्डर को सेट असाइड करके रिमांड करने के लिए रीजन देना पड़ता है, ऐसे नहीं कर सकते। आप बताइए सर्विस रिपोर्ट है रिकॉर्ड पर?
नहीं, सर्विस
नहीं है, तो डिड नॉट अपीयर का क्या मतलब? देयर इज नो डीम्ड सर्विस आल्सो, देयर इज नो ऑर्डर ऑफ डीम्ड सर्विस।
Because he was not appearing, then they.
अपीयरिंग कब होगा? जब सर्विस होगा। सर्विस का ना तो सर्विस रिपोर्ट है, ना ही डीम्ड सर्विस का कोई ऑर्डर है।
डीम सर्विस होता तो फिर पब्लिकेशन क्यों होता?
यस, पब्लिकेशन कब होता है? जब कोई अपीयर नहीं हो रहा है, इन स्पाइट ऑफ नोटिस और व्हाटएवर रीजन, और ही इज अवॉइडिंग सर्विस ऑफ नोटिस।
But here we know the notice was issued.
चलिए, WPL number 969 of 2024 for the learned counsel appearing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the improved order passed by the learned labor court, Dhanbad, passed by the learned presiding officer, labor court Dhanbad, dated 15 July 2023, is an ex parte order yes. And the order was passed without service of notice to the petitioner. The learned counsel has further submitted that the petitioner is an establishment or newspaper and has a permanent address. The notices were issued to the petitioner as per order sheet of the learned court. But the service report was not filed by the respondent, although he sought information from the concerned post office under right to information regarding service of notice. And the learned court, without recording anything with regard to service report or service of notice upon the petitioner, passed an order for publication of notice to local newspaper. It was published in Dainik Jagran on 7/11/2022, and ultimately the court proceeded as well. The learned counsel further submits that on the face of the application which was filed before the learned court by the respondent, the condition precedent for filing the case under section 2 capital A of the Industrial Dispute Act 1947 was not satisfied. He has referred to subsection 2 of section 2 capital A of the Industrial Disputes Act to submit that first the matter has to be raised before the conciliation officer, and upon expiry of the stipulated time, the cause of action to move directly before the learned labor court would arise. He has submitted that as per the application filed by the petitioner, by the respondent, the date of removal was 16/2/2021, and the conciliation proceeding is said to have closed on 15/6/2021. He submits that after the date of removal as claimed by the respondent, there has been no conciliation and therefore the impugn award is fully foreclosed. However, he submits that since the petitioner could not participate in the proceedings, no such issue was raised and the award has been passed against him. The learned counsel has also submitted that otherwise also the proceeding was not maintained as the petitioner, as the respondent was a non-working journalist and the Labour Code and the provision of Industrial Disputes Act read with
Section
the provision of the working journalist and other newspaper employees within bracket conditions of service bracket code and miscellaneous provisions of 1955 reveal that the proceeding was not available for non-working journalists. He submits that if the matter is remanded and an opportunity is granted to the petitioner, the learned court, these issues can be adjudicated by the learned court. The learned counsel appearing on behalf of the respondent has opposed the prayer and has submitted that the notice was issued and when nobody appeared, there was a direction for paying the compensation. And consequently, there was substituted service of notice. And the petitioner, having not participated in the proceedings, cannot question the service of notice and the ex parte award passed by the concerned. However, he has submitted that if this court is inclined to remand the matter before the court for consideration, then some time frame may be granted so that the matter is taken to hear. Correct? Anything else you want to say? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that on 30/7/2022, the case was filed and it was admitted, and notices were issued and the matter was adjourned awaiting service. The counsel for the applicant had filed postal receipt showing track report which did not show delivery of notice. In such circumstances, the applicant had mentioned before the court that he had filed certain application under right to information. With regard to service of notice, this happened on 29/9/2022 and the matter was adjourned for service report of notice on 2010 and was directed to be posted on 2010/2020.
It appears that there is no progress in the process issued to the OP. Hence, the applicant is directed to take steps for publication of the same in newspaper.
On 2010/2022, the applicant was present before the court and the court recorded that it appeared that there was no progress in process issued to the opposite party within that petitioner hearing and rules. He paper publication. And thereafter, the paper publication was made. In newspaper,
Yes, daily then.
in newspaper, Dainik Jagan,
Then on 7/11/20.
and after publication, the matter was sold. The next part, the order was passed. This court finds that on the face of the proceedings, the notices were issued to the petitioner, but there was no service to court. And the court directed for paper publication. It was not a case where the petitioner was avoiding service of notice, nor it was a case that the petitioner had shifted the office to another place. It further appears that no petition was also filed from the side of the applicant for substituted service of notice. Further, the petitioner has raised, accordingly, this court is of the view that the manner in which the court proceeded, which led to passing of ex parte award, cannot be sustained in the This is coupled with the fact that several issues have been argued by the petitioner by referring to the petition filed by the respondent, and the petitioner has been prejudiced in as much as no opportunity was granted to the petitioner to raise the points regarding the very jurisdiction of the since the court had no occasion to decide the points of jurisdiction, this court would not like to decide the points of jurisdiction for the first time in the jurisdiction. Accordingly, the matter is those issues are required to be decided by the learning labor court at the first instance. Accordingly, the interim award dated 15 July 2023 passed in ID case number 2 of 2022 is revised citizen, and the matter is remitted back to the concerned court for fresh consideration. The petitioner to file the written statement before the learning court within a period of 1 month from date. The parties to appear before the learning court on 3rd of January, since the parties to cooperate with the proceedings, and the final order be passed as expeditiously as possible.
3 महीने या 6 महीने
Preferably within a period of 3 months from 3rd of January.
Just something in this. On 20th September, ESIC was made a party. There was no role in this case. So, look, basically, if remand back over ESIC का term देखेगा, फिर ESIC को देखेगा.
Comes for the
20th September.
respondent.
Yes. ESIC.
Employees Provident Fund.
State insurance. State insurance.
State Insurance.
Corporation.
State
20 सितंबर
Insurance Corporation. Employees Provident Fund.
नहीं 20 सितंबर का लास्ट पैराग्राफ में ESIC को ऐड किया गया था.
EPF को भी फिर ESIC दोनों को
दोनों को किया.
दोनों को लेंगे.
Evaluated counsel for the respondent employee state insurance corporation has submitted that though they will make party in the present fields but have no role to play in the matter.
Balance.
Let it be recorded.
Obliged.
Or employees provident fund की तरफ से कोई
Nobody had appeared. Actually, there was an issue before the. Earlier, there was an issue, Your Lordship, that whether the admitted amounts have been remitted in favor of the respondent or not. That was an issue, that was a query that was put by the Honorable Court. And we ensured that the admitted amount with regards to gratuity and other PF had been released, Your Lordship. In the meanwhile, we have released them. हाँ उसमें जरूरत नहीं इसीलिए हम नहीं पॉइंट आउट किए obliged
ऐसे नहीं होता न्यूज़पेपर पब्लिकेशन इट्स अ वेरी टेक्निकल
अब जो है उसको तो हम
नहीं ऐसे वी आर जस्ट academically discussing there has to be some amendment some petition इसीलिए substituted service का
सबसे हम लोग यहाँ फाइल करते हैं हम लोग यहाँ भी फाइल करते हैं कि
यहाँ भी फाइल करते हैं ना क्या स्टेटमेंट लास्ट नोन एड्रेस में ही इज नॉट फाउंड and you do not know is present and correct
And he's avoiding
ये avoiding
ये दोनों चीज के बिना substituted service नहीं होता
नहीं अब जो है उसको तो हम इम्प्रूव नहीं कर सकते
मतलब we are just discussing that is a basic requirement for a substitute
that's why I continue
obliged
there is a passover
Passover case item 30.
Was on 3rd of January.
so he will not be available in the book for the entire prior to vacation he will not come if you WPA number 435 are appointed then the council for the parties are present आप नाम बताइए
Neeti.
MS Niti advocate submits that on account of personal reasons, Mr. Sachin Kumar advocate will not be attending court. He will be available to attend court only after the winter break, and he will not be attending court in September.
Corresponding
Says that the matter may be posted on 3rd.
My lords, as he is having some functions in his
We are aware. Counsel for the petition has no objection to the prayer for adjournment. Close this case on 3rd of January. So the deadline
ये डिसाइड हो जाएगा तो दिस विल बी द फर्स्ट क्योंकि इस पहला ऐसा केस है जिसमें कि इंटायर ग्रुप ऑफ वर्कमैन को ट्रांसफर किया गया नॉट किसी एक पर्टिकुलर आदमी को किया गया सम रिसर्च वर्क इज रिक्वायर्ड
आप करिए ना रिसर्च छुट्टी में क्या
जी
करिए रिसर्च करिए
because it requires extensive
Item 16 WPL 1530 2024.
We will file a list of dates or just एक week पहले file
Item 16 along with item 17 and 18.
Item number 16 nobody is appealing alert.
In 16.
In 16.
WPL 1544/2020.
1530.
I'm in 17.
क्या हुआ
Well, in 16 still after notice nobody is still appearing alert. And in 17 and 18 serial number says 17 18 alert. But they have been directed to file counter but they have not yet been filed.
रिकॉर्ड अगेन क्या काउंटर का काम रिकॉर्ड के
They
बाद
have
काउंटर से बहस करेंगे
They have taken time to file counter. That's why I'm
not required with the records earlier no counter is required
And for
because it's
16
WPL matter
well, and for 16 alert and for 16 alert nobody is appearing alert.
कौन सा 16
Serial number 16
आप
153.
किसमें हैं
Let you in 17 ladies.
serial number
In 17 ladies.
in 17 you are appearing
Yes, ladies.
18 maybe
No, not in
18 maybe nobody is appearing
No, somebody name is appearing in the list.
who is there में Mr. Manoj Tandon was here.
Yes.
point out on one matter, my lord. In a similar type of matter, my lord, in WPL number 6857/2016. WPL 6857 of 2016. But in that case also the same issue was involved, that whether the department is an industry or not. Malad has framed the issue and referred the matter to the labor to decide on that issue, Malad. That matter is still pending with the labor to Devral, Malad, and this is also from Devral also, Malad. And Malad, that in that issue, Malad, the pleadings are complete, the arguments have been made, and only the award has to pass in that. That is the position in the labor proposal. So,
Which is the award?
well,
जिसमें ये appeal करते हैं, बहुत पहले करते हैं. 17. 17 correct. Are you aware of this order 6857? Yes, sir.
my senior has to assist for this matter.
तो आपके सीनियर आपको क्या करते हैं?
Malad?
टाइम लेने के लिए खाली भेजते हैं.
नहीं, वैसा नहीं है. तो she'll
Sorry.
she has to assist for it.
So you assume कि टाइम हो जाएगा.
No,
Award
no.
पड़ी. Where is the award? ये तो बहुत गलत बात है. सीनियर सिर्फ आपको टाइम लेने के लिए भेजते हैं.
नहीं, ऐसा नहीं है. The award you have paid number 17.
Was any such issue framed?
No, Malad.
Was any such point raised?
Yes, a point was raised.
My contention is that no, this point was not raised. My friend says that yes, it was raised. Let him not show this.
Where is your written statement? Where is your written statement?
So that has not been annexed to another.
Where is your written statement? कुछ नहीं पता है आपको.
Look at
NCR तो आया हुआ है. आप पढ़िएगा ही नहीं तो कहाँ से क्या ही होगा.
issue was not framed in this matter, whether the department is an industry or not.
After written statement, where is your written statement? Was the case filed after some order of the writ?
No. What is the 2023?
After the case नहीं बनाया है that the case was not maintainable, they are not workmen. तो straight jacket formula थोड़ी है. Government has an immunity.
No, that was a legal issue. That can be taken at this stage also. That whether the department
Legal issue without foundational fact.
whether the department is a comes under the purview of industry or not.
ये तो it's a matter of evidence. But you have not raised such an issue.
From the section itself, well, it will not the department will not come under the definition of industry or under the idea.
Section में तो है adjournment में क्या?
And there is judgment also well, that the department or government cannot be considered as an industry, that it is not a profit making entity. And there are various judgments on that. They are not prepared from that one point of hearing itself. It may be adjourned for a
Record मंगाते हैं hearing नहीं करते हैं. Case as करेंगे. It is not a straight jacket formula. Merely because you are a department, industrial disputes will not lie. It is not a straight jacket formula. Your department is not exercising sovereign functions.
Department what for sovereign functions?
What sovereign functions? What sovereign functions? Is it sovereign function to make road? What is sovereign?
Government is a sovereign. Government is performing the sovereign function.
All departments of government do not ipso facto become industry.
There is a judgment of this honorable court itself. Justice Mukhopadhyay judgment which says that this particular department, irrigation department, is not comes under the irrigation industry. Well, next week
और आपने तो 25F खुद ही बोला है that you have given 25F. You yourself have said that you have exercised power under section 25F and then discontinued them from service.
well, this is the one judgment justice Mukhopadhyay judgment. It says that department is not an industry. Well, I'll take the copy of that judgment.
और ये जो ऑर्डर है 6857 of 2016 इसका ऑर्डर है
मतलब ये अनिश्चित फूल लगा हुआ WPL में and annexed that order of Malad in annexure 2 at page number 36. At page number 36 that order is there.
Item 17 बात करने को और कर रहा है
3826
3826 नहीं Malad is having 1544
17.
कौन से केस से बहस करेंगे कौन से केस
Item 17 1544 WPS 1544 of
ये जजमेंट आप देख लीजिए
हम देख लिए आई एम रेडी टू
that order was annexed in 382624. 382624 order लगा हुआ है
ये 6857 of 2016 आपको मिल गया नहीं ऑर्डर और जो हमने भी ऑर्डर किया वो कहाँ है
Alright. So that has been annexed in one of the
ये
regulations.
मेरा नहीं है मेरा वाला ऑर्डर नहीं है 6857 कोऑर्डिनेट बेंच का ये ऑर्डर है
6857 of 2016 is passed by your leadership.
6857 of 2016.
is 5/3/2018 और मेरा ऑर्डर नहीं है
The Malad order is there in Alba.
अच्छा ये आईए से हुआ था
हाँ
फाइनल ऑर्डर
जी बोलो फाइनल ऑर्डर है 13 जून 2024 का
किस रिकॉर्ड में है भाई 1544 of 2024 Election number क्या है?
that has been annexed in 3826 of 2024.
Well, she will bring extra copy for.
I'll bring that.
एक record से दूसरा record से
मतलब
कैसे travel करेंगे इस तरह से?
No, Lord, I'll just print all the.
This order has become final.
But the matter is pending before the London.
No, I was asking whether any appeal, etc.
No
was filed.
appeal has been filed. No appeal has been filed.
लेकिन आपने ये तीनों में same issue?
Same issue, same issue.
आप किसमें?
मतलब serial number 19, but I am paying for note.
19 अभी call out
Next,
हो गया?
नहीं, call out नहीं हुआ. But I am appearing on behalf of petition number 4 in that case. So मतलब
Connected matter is.
Connected
no, it is not connected.
अभी
It's
19
after
second आपने
that.
call करेंगे, second आपने call करेंगे.
I am praying for time.
बिना record देखे case adjourn नहीं